Imprudence is an act by reckless imprudence, which, had it been intentional, would constitute a grave felony, less grave felony, or a light felony. Negligence is an act by simple imprudence or negligence, which would otherwise constitute a grave felony or a less serious felony, or causing wrong by simple imprudence or negligence, which, if done maliciously, would have constituted a light felony. Article 365. Reckless imprudence consists in voluntary but without malice, doing or failing to do an act from which material damage results by reason of inexcusable lack of precaution on the part of the person performing or failing to perform such act, taking into consideration his employment or occupation, degree of intelligence, physical condition, and other circumstances regarding persons, time, and place. Simple imprudence consists in the lack of precaution displayed in those cases in which the damage impending to be caused is not immediate, nor the danger clearly manifests. 1969 Bar Exam. Failure to lend on the spot to the injured parties such help as may be in his hands to give is a qualifying circumstance. Reckless imprudence resulting in arson. One night when there was a Morocco brownout, A wanted to pour gasoline from a container into the gas tank of his car. He got a candle, lighted it, and asked B to hold it, but while A was pouring the gasoline, the gas ignited and the flames immediately enveloped the ground floor of A's house. The tenants occupying the premises suffered first-degree burns and their properties destroyed as a consequence of the fire. A's mother-in-law, who was then on the upper floor of the house upon seeing the flames, jumped to the ground and sustained cranial fracture. The child of A was also caught by the flames and perished. The crime committed is reckless imprudence resulting in arson, homicide, serious physical injuries, and damage to property. People v. Pakson, CA 46 OG 2165. In a children's party, G left his loaded and cocked pistol on a chair amidst children playing around to meet visitors. All of a sudden, the chair was bumped by a child being chased by his playmates, causing the pistol to fall on the ground and fired. This created considerate shock and fear among the persons present thereat, especially the children, who scampered for safety. 1977 Bar Exam. Leaving a loaded firearm on a chair within the reach of a child, then playing in the place constitutes reckless negligence. Viada, Volume 3, page 629. Since this negligent act created considerate shock and fear among the persons present thereat, G is liable for simple negligence resulting to alarm and scandal. Firing a gun at a person to scare him constitutes discharge of firearm. If the bullet hit a wall and bounced back and hit another person, killing him as a consequence, he is responsible for homicide because of Article 4 of the Revised Penal Code. Since single act produces two crimes, he is liable for compound crime of homicide and discharge of firearm. Firing a gun in a public place causing people to scamper away constitutes alarm and scandal. If as a consequence of alarm and scandal, a person was hit by the bullet and died, the offender is liable for homicide because of Article 4 of the Revised Penal Code. During a concert of Gary V, and in order to prevent the crowd from rushing to the stage, Rafael Padilla, a security guard, pointed his gun at the onrush of people. When the crowd still pushed forward, Rafael fired. However, the bullet hit one of the metal roof supports, ricocheted, and then hit one of the stage crew members, causing injuries which resulted in the latter's confinement in a hospital for 12 days. 2007 Bar Exam. Pointing a gun and firing it at the unruly audience is beyond the performance of the duty of a security guard. Common sense dictates that firing a gun at the audience will cause them to scamper away, and death may result as a consequence. A security guard is ought to know that firing at the audience is not a solution to prevent them from being unruly. The act of the security guard in this case constitutes at least alarm and scandal. Hence, he is also liable for the less serious physical injuries because of Article 4 of the RPC. In People v. Abarca, GR L 74433, September 14, 1987, the accused was absolved from criminal liability for killing the paramour of his wife. It was held the accused did not commit a felony for the death of the paramour, since it is the proximate result of the outrage overwhelming the accused after chancing upon his spouse in the act of infidelity. However, he was not exempted from criminal liability with regard to the injury sustained by third persons. It was held that this does not mean, however, that the accused is totally free from any responsibility. Granting the fact that he was not performing an illegal act when he fired shots at the victim, he cannot be said to be entirely without fault. While it appears that before firing at the deceased, he uttered warning words, "Anwaray, labut, kagawas," that are not enough precaution to absolve him for the injuries sustained by the victim's negligence that was found on his part, under Article 365. In People v. Galakda, the accused has the lawful right to defend himself against unlawful aggression. However, he did not aim at his assailant, but instead indiscriminately fired his deadly weapon at the risk of the life and limbs of innocent persons. His act of indiscriminately firing his gun without due care in a thickly populated area of Metro Manila constitutes the crime of discharge of firearm. Hence, he is liable for injuries sustained by the victims as a direct, natural, and logical consequence of unlawful discharge of firearm. In a Barca case, the accused discriminately aimed and fired the gun at the paramour of his wife. For firing a warning shot without the least intention of causing injury to anyone by the policeman in the performance of duty does not constitute alarm and scandal, or discharge of firearm. If the bullet hit a bystander who died as a consequence, he is not liable for homicide since he is not committing a felony in firing his gun. Article 4 is not applicable. However, the policeman is liable for reckless imprudence resulting to homicide if he failed to take the necessary precaution demanded by the circumstances as to time and place in firing a warning shot. Firing a gun in the air and at the ground to stop two persons from having a fist fight is not constitutive of alarm and scandal, since there is no evil intent to cause alarm. If the bullet, when it hit the ground, ricocheted and hit another person who died as a consequence, the accused who fired the gun is not liable for homicide. Article 4 is not applicable since he is not committing a felony. However, he is liable for reckless imprudence resulting in homicide if he failed to take precautions demanded by the circumstances, such as the district was populated and the likelihood that his bullet would glance over the hard pavement of the Manila thoroughfare. People v. Nukum, GR L 482. In the course of funeral procession, a young mourner who was marching momentarily stopped down to tie her shoelaces, which had become untied. The driver of the hearse, who was driving at 5 miles an hour, was then looking at the stores by the roadside and did not see her. He continued to drive on and run over the girl. When the people around shouted and gestured, he backed up and ran over the girl a second time, killing her. 1988 and 2001 bar exams. The normal reaction of any person who had accidentally run over another would be to immediately alight from the vehicle and render aid to the victim. People versus Castillo Jr., GR 121768, July 21, 1997. Backing up and running over the victim for the second time shows deliberate intent to kill the victim. Hence, he should be charged with murder. Accused cannot be charged with reckless imprudence resulting in frustrated homicide, 1973 and 1989 bar exams, in People versus Castillo. It was held that there can be no reckless negligence resulting in frustrated homicide inasmuch as reckless negligence implies lack of intent to kill, and without intent to kill, the crime of frustrated homicide cannot exist. Yapyuko, GR numbers 12074446, June 25, 2015. However, if the victim died, he can be charged with reckless imprudence resulting in homicide. To make a doctor liable for reckless imprudence resulting in homicide, it must be shown that he did not treat his patient in accordance with the standard of care and skill commonly possessed and exercised by similar specialists under similar circumstances. Failure to present specialists as witness to testify on this standard is fatal to the prosecution of the case. Solidum versus People, GR 192123, March 10, 2014. In Chris versus CA, GR 122445, November 18, 1997, the lower court bewails the following circumstances: inadequacy of the facilities and untidiness of the clinic, the lack of provisions, the failure to conduct pre-operation tests on the patient, and the subsequent transfer of Lydia to San Pablo Hospital and the reoperation performed on her by the accused. Expert testimony should have been offered to prove that the circumstances cited by the courts below are constitutive of conduct falling below the standard of care employed by other physicians in good standing when performing the same operation. A physician is presumed that he takes the necessary precaution and employs the best of his knowledge and skill in attending to his clients. This presumption is rebuttable by expert opinion, which is so sadly lacking in the case at bench. Moreover, above stated circumstances do not indicate that accused was recklessly imprudent in the exercise of her duties as a surgeon. Accused was acquitted. In Garcia versus People, GR 187926, February 15, 2012, Roy Jr., who was hit by a taxi cab, was rushed to the hospital for emergency medical treatment. The X-ray of his ankle result showed no fracture as read by Dr. Garcia, a junior resident. The mother of victim asked for X-ray of the leg of her son. Dr. Bastan, after conducting her own examination of the victim, informed the mother that since it was only the ankle that was hit, there was no need to examine the upper leg. 11 days later, victim developed fever, swelling of the right leg, and misalignment of the right foot. It was later found through X-ray that the victim suffered fractures in the shaft of the bone. Held, the court is not convinced with moral certainty that the resident doctors are guilty of reckless imprudence or simple negligence. The elements thereof were not proved by the prosecution beyond reasonable doubt. The testimony of a specialist in pediatric orthopedic, although pointing to some medical procedures that could have been done by the two accused as physicians in duty, was not clear as to whether the injuries suffered by patient Roy Jr. were indeed aggravated by the accused's judgment call and their diagnosis or appreciation of the condition of the victim at the time they assessed him. Olympio went to a drugstore to buy paracetamol. The pharmacist sold him 3 tablets. Upon arriving home, he took a tablet. 1 hour later, he had a seizure and died. The autopsy showed that the tablet he had taken was not paracetamol, but a pill to which he was allergic. 2008 bar exam. Olympio is not liable for murder qualified by the circumstance of by means of poison, since there is no showing of intent to kill on his part. However, he is liable for reckless negligence resulting to homicide. In People versus Castillo, it was held that the profession of pharmacy demands care and skill, and druggists must exercise the highest degree of care known to practical man, so that human life may not constantly be exposed to the danger flowing from the substitution of deadly poisons for harmless medicines. In People versus Tumayag, GR 172778, November 26, 2012, Section 37 of RA 4136 mandates all motorists to drive and operate vehicles on the right side of the road or highway. When overtaking another, it should be made only if the highway is clearly visible and is free from oncoming vehicle. Overtaking while approaching a curve in the highway where the driver's view is obstructed is not allowed. Corollarily, drivers of automobiles, when overtaking another vehicle, are charged with a high degree of care and diligence to avoid collision. The obligation rests upon him to see to it that vehicles coming from the opposite direction are not taken unaware by his presence on the side of the road upon which they have the right to pass. In a criminal case involving a motor vehicle accident, the trial judge found the accused driver recklessly imprudent, but likewise concluded that the injured complainant was guilty of contributory negligence. 1974 bar exam. The accused is liable for the crime of reckless imprudence resulting in physical injuries. The contributory negligence of the victim does not exonerate the accused. The defense of contributory negligence does not apply in criminal cases involving crime committed through reckless imprudence, since one cannot allege the negligence of another to evade the effects of his own negligence. Ginubiangon versus Court of Appeals, GR L 40452, October 12, 1989. However, such contributory negligence will mitigate the amounts of civil liability imposed upon the accused. People versus Tumayag, GR 172778. Last clear chance rule. The doctrine of last clear chance provides that where both parties are negligent, but the negligent act of one is appreciable later in point of time than that of the other, or where it is impossible to determine whose fault or negligence brought about the occurrence of the incident, the one who had the last clear opportunity to avoid the impending harm, but if failed to do so, is chargeable with the consequences arising therefrom. Stated differently, the rule is that the antecedent negligence of a person does not preclude recovery of damages caused by the supervening negligence of the latter, who had the last fair chance to prevent the impending harm by the exercise of due diligence. Green Star Express versus Universal Robina Corporation, GR 20-50-90, October 17, 2016. Emergency Rule. Under the emergency rule, one who suddenly finds himself in a place of danger and is required to act without time to consider the best means that may be adopted to avoid the impending danger is not guilty of negligence. If he fails to adopt what subsequently and upon reflection may appear to have been a better method, unless the emergency in which he finds himself is brought about by his own negligence. Oryx Metro Leasing and Finance Corporation versus Mangaliniao, GR 174089, January 25, 2012. And that is for your criminal negligence. And if you like this content, go ahead and hit that subscribe button. It's free. I would really appreciate it. Also, you can drop your suggestions in the comment box or shoot me an email. Thanks.